There's a particular kind of silence that falls over a room when someone realizes they've made a catastrophic mistake. Not the silence of shock. Not the silence of grief. The silence of a trap snapping shut. I know that silence well. I've heard it in courtrooms, in conference rooms, in the offices of lawyers who thought they had the upper hand. I heard it in my own kitchen on a Tuesday afternoon in October, when my daughter-in-law Renata slid a legal document across my kitchen table and told me to sign or lose everything. What she didn't know, what none of them knew, was that I had been waiting for exactly this moment. My name is Dorothy Caldwell. I am 71 years old. I have silver hair I stopped apologizing for at 62, reading glasses I keep on a chain around my neck, and a reputation in this town for making excellent lemon pound cake. What most people don't know, what I deliberately stopped mentioning after I retired, is that I spent 31 years as one of the most respected estate planning attorneys in the state of Georgia. I wrote the textbook. Literally. A 2-volume reference guide on elder law and asset protection that is still used in 3 law schools. But when my husband Franklin got sick, none of that mattered anymore. What mattered was being there. Holding his hand during the infusions, learning which nurses worked the night shift and which ones were gentle with the IV lines, making sure he could hear his Coltrane records from wherever he was resting. Franklin died 18 months ago. Pancreatic cancer. 7 months from diagnosis to the end. And within 6 weeks of his funeral, Renata began making her move. Beat 1. The setup. Franklin and I had one son, Marcus. He is 44 years old, handsome in the way Franklin was handsome, with those same deep-set eyes and that same slow smile that used to stop me cold when I was young. Marcus married Renata 11 years ago. She was a corporate event planner, organized, polished, always dressed like she was expecting photographers. I tried to love her. I really did. I brought her into the firm's holiday parties. I recommended her business to 3 of my colleagues when she was just starting out. I babysat their daughters, my granddaughters, Lily and June, every Friday night for 4 years so she and Marcus could have time to themselves. But Renata never quite trusted me. I think it was the money. Franklin had done well. He'd built a commercial real estate company from nothing, and by the time he retired, the portfolio was worth just over $4 million. The house in Buckhead, a lake property in Tennessee, several income-producing units in Midtown. And because I am an estate planning attorney who knew exactly what she was doing, I had structured everything carefully over 30 years of marriage, trusts, proper titling, beneficiary designations that couldn't be easily challenged. Renata wanted to know where it all went. She asked Marcus. Marcus asked me. I told them both the same thing. Franklin and I made our plans together. And when the time comes, everything will be handled properly. That answer didn't satisfy her. I noticed things changing slowly. The way seasons change, you don't see the exact moment summer becomes fall, but one morning you reach for a sweater and realize it's been cold for a while. Phone calls from Marcus became shorter. Sunday dinners became monthly. Monthly became occasional. Renata started CCing herself on emails between Marcus and the family accountant. She started showing up at the Midtown properties to check on things, without telling me. She hired a financial advisor, not for her own accounts, but specifically to advise on what she called the Caldwell family estate situation. And then 2 things happened that I cannot prove were connected, but I believe with my whole heart were not coincidence. First, I noticed a signature on one of Franklin's retirement account transfer documents that didn't look right. I'd watched Franklin sign his name thousands of times. The loop on the F. The way he always lifted his pen slightly before the second syllable. This signature was close. But it wasn't his. Second, 3 weeks after I quietly noted this discrepancy, Marcus sat me down at my own kitchen table and told me he was worried about me. He said I seemed confused lately. That I'd left a burner on. That I'd forgotten a lunch we'd apparently planned, a lunch I have no memory of agreeing to. That I'd left a voicemail for Renata that didn't make sense. I asked to hear the voicemail. He said he'd deleted it. I sat with that conversation for 3 days. And then I did what I always do when something doesn't add up. I started taking notes. Beat 2. The silent move. For the next 18 months. While I was baking lemon pound cake and attending my book club and picking up Lily and June from school on Tuesdays, I was also building a case. I contacted a forensic document examiner I'd used during my years of practice. Her name is Patricia Osei, and she is one of the best in the Southeast. I sent her photographs of the suspicious signatures without telling her whose they were or why I was asking. Her report came back in 2 weeks. 3 of the signatures were inconsistent with the known authentic samples I'd provided. Not definitively forged, that would require court testimony, but inconsistent enough to raise serious questions. I called in a favor from a former colleague at a firm across town. Asked him to pull the filings on 2 of the account transfers quietly. He didn't ask questions. We'd known each other since 1989. What he found was that one of the transfers, a $312 rollover from Franklin's brokerage account, had been redirected to a joint account in Marcus and Renata's names, 11 days before Franklin died. 11 days. Franklin had been unconscious for most of those 11 days. I did not confront Marcus. I did not call Renata. I did not tell a single person what I had found. Instead, I called my attorney. Yes, even attorneys need attorneys. A woman named Claudette Marsh who practices in Savannah and has never met Marcus or Renata in her life. I had her quietly update my own estate documents, create a protective trust for the lake property and the Midtown units, and draft a detailed affidavit of my current mental competence, signed off by my physician, a neuropsychologist I hired privately, and 2 colleagues who'd worked with me professionally within the past year. I smiled at Renata at Thanksgiving. I sent Christmas cards. I let Marcus take me to brunch and talk about how he was keeping an eye on things. I was the picture of a sweet, slightly scatterbrained grandmother who needed looking after. And I waited. Beat 3. The trap sprung. The document Renata slid across my kitchen table was a durable power of attorney. Broad authority. Covering financial decisions, property management, legal matters. She'd brought it on a Tuesday afternoon when Marcus was conveniently at a conference in Charlotte. She sat across from me in my own kitchen, her hands folded on the table, wearing a cream blazer and that particular expression I'd seen on opposing counsel many times over the years. The one that says they think they've already won. "Dorothy," she said. She never called me Mom. Not once in 11 years. "Marcus and I have been talking. And we're really concerned. You've had some episodes lately. We think it would be best if we helped manage the properties. Just until you're more settled." I looked at the document without touching it. The law firm's name on the letterhead was Whitfield and Associates. I knew that name. Bradley Whitfield had clerked for me as a summer associate in 2004. I'd written his bar recommendation letter. I'd attended his wedding. "And if I don't sign?" I asked, keeping my voice soft and uncertain. Still playing the role. Renata's expression didn't change, but something behind her eyes did. "Then we may have to pursue a formal competency evaluation. Through the courts. Marcus doesn't want that, but if we have to protect you from yourself, we will." Protect me from myself. I let the silence sit for a moment. Then I uncapped my pen. Looked at the document. Looked at Renata. And I said, quietly, without any heat in my voice at all, "I drafted this clause, Renata. Section 4C, the Emergency Asset Management Provision. I wrote the original version of it in 1997 for the Georgia State Bar's Model Documents Committee. And I personally trained the young man whose name is on this letterhead. I attended his wedding." I set the pen down. This document won't hold up for 60 seconds in front of a judge. Would you like me to tell you why? The cream blazer couldn't hide the color draining from her face. Beat 4. The discovery. Renata left my kitchen in a hurry. No ceremony, no goodbye. Just the sound of heels on hardwood and my front door closing harder than necessary. I gave her 48 hours. Then I called Claudette in Savannah and told her it was time. The competency petition arrived at my door 9 days later. Marcus had signed it. I read it carefully, all 11 pages. Sitting in my reading chair by the window where the afternoon light comes in best. I noted the procedural errors. I noted the overreach in the requested relief. I noted that whoever had drafted it, and I suspected it wasn't Bradley Whitfield himself, because Bradley knew better, had made a foundational mistake in citing the standard of evidence required. And then I called Marcus. He answered on the third ring. Marcus, I said, I've received the petition. I want you to know I'm not angry, but I need you to understand something very clearly before this goes any further. Mom, I'm going to be in Judge Patricia Delaney's courtroom in 3 weeks. Patricia was my student at Emory in 1998. I will be representing myself. And I will be bringing evidence of the $312 transfer that occurred 11 days before your father died, when your father was not, by any medical definition, capable of authorizing a financial transaction. Silence. If you want to stop this right now, I said, I am willing to sit down with Claudette and work out something fair, something your father would have approved of. But if you walk into that courtroom, Marcus, everything comes out. Everything. He didn't stop it. I think Renata wouldn't let him. And so 3 weeks later, on a gray Wednesday morning in November, I put on my navy wool suit, the one I hadn't worn since my retirement party, pinned Franklin's pocket square to the lapel, and drove myself to the Fulton County Courthouse. The courtroom was smaller than I remembered from my years of practice. Or maybe I just felt larger. Marcus and Renata were already seated at the petitioner's table. Renata wore black. I noticed that. Performative mourning for a woman who wasn't dead yet. Their attorney was a young man I didn't recognize. Not Bradley Whitfield. Apparently Bradley had removed himself from the matter after my kitchen conversation with Renata. Smart boy. I'd trained him well. The new attorney's name, according to the court filing, was Derek Souza, 37 years old. 7 years of practice. Competency cases were, apparently, a specialty. He looked at me the way people look at a closed door, not thinking about what might be on the other side. I took my seat at the respondent's table alone, arranged my files with the precision of someone who has done this 10,000 times, and waited. Judge Patricia Delaney entered at exactly 9 o'clock. She was 53 now. I remembered her at 24. Nervous and brilliant, sitting in the front row of my elder law seminar with a yellow highlighter she clicked constantly when she was thinking hard about something. She saw me the moment she sat down. Her expression didn't change. Good judges learn that early, but I saw the slight widening of her eyes, the almost imperceptible pause before she opened her folder. Let's begin, she said. Petitioner's counsel, you may open. Derek Souza was practiced and confident. He laid out his case cleanly. A 71-year-old widow, living alone, managing a complex multi-property estate without professional guidance. Multiple reported incidents of confusion and forgetfulness. Family members concerned for her safety and the preservation of her late husband's assets. He used the word, vulnerable, 4 times in his opening. He used the phrase, for her own protection, twice. When it was my turn, I stood slowly, buttoned my jacket, and walked to the center of the room with the unhurried deliberateness of someone who owns every square inch of the floor they're standing on. Your Honor, I said. My name is Dorothy Margaret Caldwell. I practiced estate planning law in this state for 31 years. I am the author of Caldwell on Elder Law and Asset Protection, currently in its 3rd edition. I served on the Georgia State Bar's Model Documents Committee for 9 years, and on the Fiduciary Law Section Steering Committee for 6. I am currently consulting on 2 active estate matters through a of-counsel arrangement with Marsh & Associates in Savannah. I am also the respondent in this proceeding. The silence in that courtroom was extraordinary. Derek Souza had gone very still. Marcus was staring at the table. Renata was staring at me, and for the first time in 11 years, the composure was gone. I would like to submit to the court, I continued, the following: a neuropsychological evaluation conducted 6 weeks ago by Dr. Amma Quarshi of Emory, showing cognitive function in the 94th percentile for my age group. A letter from my internist affirming my physical health and full mental capacity. Affidavits from 4 colleagues who have worked with me professionally within the past 12 months. And an updated asset schedule showing that every property in the Caldwell estate is properly titled, currently insured, tax compliant, and generating positive cash flow. I set the folders on the clerk's desk with a soft, final sound. I am also prepared, I said, turning just slightly toward the petitioner's table, to introduce evidence of a $312 transfer from my late husband's brokerage account that occurred 11 days before his death, accompanied by a forensic document examiner's report raising significant questions about the authenticity of the authorization signature. Derek Souza was on his feet. Your Honor, that's outside the scope of this proceeding. Counsel, Judge Delaney said, and the single word landed like a gavel. She looked at him the way I used to look at first-year associates who'd interrupted a senior partner. Sit down. She looked at me. Mrs. Caldwell, she said, and I caught the slight emphasis. The careful formality she was using to keep her professional composure intact. Are you prepared to present that evidence today? I am, Your Honor. Then we'll hear it. Beat 5, the final balance sheet. What happened over the next 4 hours was not dramatic in the way courtroom scenes are dramatic on television. There were no outbursts, no shouting, no tearful confessions. What there was, instead, was the methodical, relentless dismantling of a case built on the assumption that I was someone other than who I am. Patricia Osei testified by video about her findings on the signatures. My former colleague submitted the account transfer records and the timeline. My physician testified to my cognitive health. And I cross-examined every witness Derek Souza brought forward with the precision of 3 decades of practice. The neighbor who claimed I'd seemed confused. I established under questioning that she'd seen me once, briefly, through a car window, and had spoken to Renata about it the following day before she'd spoken to anyone else. The so-called forgotten lunch? I produced my calendar, the same paper planner I've kept for 30 years, showing no lunch had ever been scheduled. The voicemail Renata had apparently complained about? Derek couldn't produce it. It had been deleted. By mid-afternoon, Derek Souza asked Judge Delaney for a recess. She gave him 15 minutes. When we reconvened, he stood and said, in the flat, careful voice of a man swallowing something very bitter, petitioners wish to withdraw the competency petition. Judge Delaney looked at him for a long moment. Then she looked at me. Mrs. Caldwell, do you wish to make any further motions? I stood. Yes, Your Honor. I move that the court refer the matter of the disputed account transfer to the district attorney's office for review. I am not making a formal criminal allegation today. That is not the purpose of this proceeding. But the evidence I've submitted is a matter of public record now, and I believe the appropriate authorities should be aware of it. Renata made a sound. Just a small sound, quickly suppressed, but I heard it. Granted, said Judge Delaney. The court will refer the transfer documents to the DA's Financial Crimes Unit for review. Court is adjourned. I walked out of that courthouse into cold November air. And I stood on the steps for a moment, my face turned up toward the white sky, thinking about Franklin. He would have loved this. He used to say I was the most dangerous person in any room, not because of anything I did, but because of what people assumed I wasn't. Marcus called me that evening. He didn't say much at first. Just breathed on the line for a moment the way he used to when he was small and had done something wrong and didn't know how to start. "Mom," he finally said. "I didn't know about the transfer. I want you to know that. I didn't know." I believed him. That was the worst part. I believed him completely. "I know, Marcus." She told me it was. She said Dad had set it up. That it was already planned. "I know. What happens now?" I thought about that for a moment. The lake property where Marcus had learned to fish. The Sunday dinners Franklin had insisted on even when Marcus was a teenager and would rather have been anywhere else. The particular way Marcus had held his daughters at the hospital when they were born. That careful, terrified tenderness of a new father. "What happens now," I said, "is up to you. I am your mother. I am not your enemy. But I will not be managed. And I will not be diminished. And I will not pretend that what happened is something we can simply move past without some honesty between us." He was quiet for a long time. "I'm sorry, Mom." "I know you are. Can I come over? Saturday. Just me. Without." He paused. "Just me?" "Come for lunch," I said. "I'll make your father's lemon pound cake." The DA's Financial Crimes Unit opened a formal inquiry 6 weeks later. Renata retained her own attorney. Not Derek Souza. Someone else. The $312 was repaid to the estate within 90 days. As part of an agreement I will not discuss in detail. What I will say is that my attorney Claudette Marsh did excellent work, and that the lake property in Tennessee now belongs outright to a trust I established for Lily and June, my granddaughters, to be available to them when they turn 25. Marcus comes for lunch most Saturdays now. Sometimes he brings the girls. Lily has started asking me about law school. She's 16 and terrifyingly sharp. And every time she argues with me about something, really argues, with evidence and structure and that bright combative look in her eyes, I think, there she is. There's the next one. Renata and I are not friends. We may never be. But she knows now what she is dealing with. And in 11 years, that understanding has produced something I never expected. A careful, distant, functional respect. I will take it. I am 71 years old. I have silver hair I stopped apologizing for at 62. I keep reading glasses on a chain around my neck. I make excellent lemon pound cake. And I am, as anyone who has ever sat across from me in a courtroom could tell you, the most dangerous person in any room they've ever walked into. They just never see it coming. And that was just the beginning. Because what happened next? 3 months later, when Lily found something hidden in Franklin's old filing cabinet, I never saw coming. Subscribe so you don't miss what comes next.